The next move by this mafia corporation was to secretly hire the chairman of the Democratic Party's Rules Committee. His name is Ralph Curtis Dawson. Dawson said to AT&T, "Oh, don't worry guys, I am the chairman of the political party, of the Democratic Party, I can manage, don't worry." Mr. Dawson, he had a guy by the name Brian Tilker. You see the good-looking guy here behind me? This guy, he filed an affidavit. They didn't allow me to have any discovery. The judge assigned to this case is by the name Joanna Seibert, who was appointed by Bill Clinton, President Bill Clinton. So, you know, President Clinton is Democrat, this woman is a parrot of the Democrat. Now, Mr. Tilker and Mr. Dawson filed a motion for summary judgment. Motion for summary judgment means, motion again is a request to the court. Motion for summary judgment means they want the court to dismiss the case on certain grounds without going into a hearing and trial and all these things, which they never wanted to begin with. 33 years they never wanted a trial, because if the trial were to be held, they know the conclusions are foregone. Okay? So Mr. Dawson filed a motion to dismiss. Motion to dismiss. Okay? Motion to dismiss means throw the case out without any hearing, without any trial. The issue before the court, folks, in 1982 was whether the release the defendant obtained from me on August 25, 1981 is valid or not. If it is not valid, as stated by the U.S. Supreme Court in Alexander v. Denver Gardner, if the release is obtained not freely, not voluntarily, not knowingly, then it is a voidable agreement, unenforceable. And the burden of showing that the release is valid is upon the defendants. They have to prove this release is valid, not me, because I contested the release. They can put a gun on your neck and say, "I will shoot you if you don't sign." You understand? I had no other option, sign the damn papers saying that I quit the job. Did I quit my job, folks? My former wife has testified for one full day. I was fired in her invited presence. I testified for 3 full days. In my deposition, I didn't quit the job. They fired me illegally in violation of the law. Now, the defendant could not prove the release is valid during the last 33 years. If you have a piece of paper which is not valid, what are you going to do with that? What are you going to do with that, folks? Oh, the defendant contrived yet another scheme. Okay, they told this good-looking guy, Mr. Tilker, filed an affidavit, a sworn affidavit. You're going to see his affidavit. Tilker says in his 3-page affidavit that he has personal knowledge about my signing a release on August 25, 1981. Folks, listen to me very carefully. You are smart gentlemen, ladies. this guy, Tilker, he was born on May 5, 1979. 1979. He is born in May 5, 1979. And he says, in New York, he was born in New York. He says in affidavit, sworn affidavit, which was sworn, notarized before a notary public, he has personal knowledge. 2-year-old kid, 2 years and 3 months old guy, going still in his diaper in New York, he says to the federal judge, Joanna Seibert, ma'am, I am submitting this affidavit because I have personal knowledge. Does he have personal knowledge? Somebody living in New York? I am signing a release in Michigan, Detroit, which is approximately 1,500 miles away. 2-year-old guy saying, sworn affidavit. And who is asking him to do it is Mr. Ralph Curtis Dawson, a Columbia School graduate, law school graduate. He is the chairman of the political party. He is telling Mr. Tilker, file an affidavit, we will see, do it my way. Mr. Dawson filed several affidavits. Mr. Tilker, he filed one, this is his pleadings. It was dated June 8. At that time he didn't say he has personal knowledge, but they know that it can't fly. So they amended it on October 15th. Okay? In the latest amended pleading, which is submitted to the court and upon which the judge rendered the decision subsequently, he says, I have personal knowledge of the facts stated here on August 25, 1981, Mr. David signed a release in Michigan. Folks, what is that called? In legal terms, it is perjury. Perjury, making false statement before a federal judge to obtain a summary judgment. Folks, based on Tilker's affidavit, this, pardon my French, and I call and spit on her face, this bitch grants a motion for summary judgment. A federal judge accepting a 2-year-old's affidavit brought her another motion. Judge Seibert, this guy cannot testify. The only issue in this case is whether the release is valid or not, which the defendants could not prove in 33 years. How can you rely upon this 2-year-old guy's affidavit for gospel truth? She says in her another order, amended order, Mr. Tilker can do so. An attorney admitted to practice law. When he was 2 years old, he is making an affidavit saying he has personal knowledge about events that took place in 81 when he was 2 years old. She says that's okay, he is Tilker, he went to St. John's University like I did. I graduated from St. John's, so does Tilker. He can do so. Folks, as I said before, Tilker was lying. Clearly, anybody with common sense understands a person 2 years old cannot testify what happened in another town in 1981. And who asked him to lie is this guy, Mr. Ralph Curtis Dawson. Mr. Dawson is a partner at a major law firm, an international law firm, Fulbright and Jaworski. The firm has recently merged with another international firm called Rose Norton, Fulbright and Jaworski. The new firm has nothing to do with what Mr. Dawson did or Mr. Tilker did. Folks, so far I have told you the hanky-panky going on in the courts. I wanted to say this at the outset, which I forgot to. There are so many federal judges and state court judges who are honorable, thorough, knowledgeable. They are there to interpret and apply the law fearlessly, impartially, based on the promise they took that they will interpret and apply the law. But there are also crooked judges. You will see who they are, how the deal's going on. Now we are going to go into a third area of the litigation, and I am going to expose all those crooked and corrupt judges and appeal court judges. Tilker, after filing the affidavit, and Mr. Dawson filing the motion for summary judgment, accompanied by his affidavit, this bitch, Joanna Seibert, granted the motion, quoting Tilker's affidavit as many as 12 places. The basis of granting a motion for a summary judgment is Tilker's affidavit. Tilker said so. We are going to show you a copy of a ruling. It's a first 19-page order, second 10-page order, and the second 10-page order, I'm reading from the order. On page 4, she says, Tilker affidavit. Plaintiff argues in his amended motion for reconsideration that Brian Tilker, defense counsel, falsely stated he had personal knowledge of the facts in his affidavit. Plaintiff argues that since defense counsel's affidavit contains a false statement, the entire affidavit should not have been considered by the court. Folks, let me finish reading, then I will go into the argument. Thus, plaintiff reasons, without the use of the defense counsel's affidavit, the court should have denied the defendant's motion for summary judgment. Plaintiff's amended motion for reconsideration, paragraph 5 and 6. Nevertheless, plaintiff's argument fails for two reasons. First, defense counsel's affidavit is simply categorizing evidence that could properly be considered on a motion for summary judgment. Tilker affidavit. She is saying Tilker's affidavit is simply categorizing evidence. Folks, under the rules, the party interposing release has the preliminary burden to present the original affidavit. The sworn, not affidavit, the original release, which defendants do not have. Then they have to show every element of the release is valid. None of them from either of these companies want to come forward and show that. So they bring in this paid puppet Tilker, who was still going in his diapers, affidavit. And she says, what he is doing is simply categorizing the evidence admissible. Okay? She doesn't know what is admissible evidence. Can a 2-year-old kid submit admissible evidence in the federal court? for the defendants to prevail on a motion for summary judgment? Folks, in 1982, Judge John Reed, the first judge, already stated in one of these status conferences, there is a triable issue of material facts exists in the case. A triable issue of material fact exists in the case. The US Supreme Court, in the trilogy of the cases decided by it in 1989, 3 precedent-setting cases, I am not going to read them, you can see it, says a motion for summary judgment can only be granted if there are no triable issues of material facts. If there is an issue with regard to the material facts, the summary judgment must be denied. That's the holding of the US Supreme Court. This woman says, yes, there is no triable issue, Mr. Tilker said so. That's the basis upon which she is dismissing and Title VII, ADA, ERISA, and breach of contract claims. This slut, I hate to see this bitch retire, or the Senate Judiciary Committee investigate her dealings. Folks, now defendant has yet another trick. Now they got to get another panel in the Court of Appeals. Before I finish this, let me complete what I was reading from her judgment, which says, first, defense counsel's affidavit is simply categorizing evidence that could properly be considered on a motion for summary judgment, Tilker affidavit. An attorney's affidavit is valid when it is merely a vehicle placing before the court relevant admissible documents. She says this admissible document, relevant document. So what this 2-year-old kid was doing was testifying. She says, yes, his testimony is valid. He is only placing before the court admissible evidence. Why? Then he has to notarize this affidavit. If it is not his testimony, he is only placing before the court admissible evidence. She has to define what is admissible evidence here. Then she is citing a case. Okay, all the cases she is citing are rejected by the Supreme Court and other Court of Appeals. Now she is further going on to say, not only is this practice, is this practice allowed, it is considered commonplace on summary motions. And she is citing United States versus Lester, Southern District of New York. Another court saying, yeah, it's admissible evidence. Okay. Moreover, plaintiff never argued that the defense counsel's affidavit was invalid in his prior submission. Accordingly, the court refuses to entertain plaintiff's new argument now on a motion for summary judgment. Then she goes on to further goes on to say the release. The release is governed by the law where the most important events regarding the dispute took place. Okay, she is citing a case, Spink versus whatever it is not even readable. Because the release was signed in Michigan, it is therefore governed by the Michigan law. Now she is going to a different area. The first judge, he is denying the motion, saying that the release has to be established. It has to be proven that it was given by me freely, voluntarily, and knowingly. This slut changes the whole thing. She says no need for a trial. She can grant a summary judgment based on Tilker's attorney affidavit. So, okay, it's all justified. Folks, there are canons of ethics. The canons of ethics, especially the DR 8.4, clearly states what they say here. I am reading from the DR A lawyer or law firm shall not, emphasis added, violate or attempt to violate the rules of professional conduct, knowingly assist or induce another to do so through the acts of another, a law firm. Okay? Engage in illegal conduct that adversely reflect on the lawyer's honesty, trustworthiness, or fitness as a lawyer. Engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. D. Engage in conduct that is prejudicial to the administration of justice. E. Knowingly assist a judge or judicial officer in conduct that is violation of the applicable rules of judicial conduct or other. F. Engage in any other conduct that adversely reflect. It goes on to say what lawyers are forbidden not to do. Lawyers cannot do these things. What Mr. Dawson, who is the chairman of the Democratic Party's Rules Committee, is trying to do is in flagrant violation of these rules, the canons of ethics. And Mr. Tilker who submitted the false of it was also doing the same thing as a deal under the table. I don't know how many of you seen Charlie's Angels, the television series. You don't see the Charlie, the angels do the work. Here Mr. Dawson is the invisible Charlie. Okay? Mr. Dawson never ever came to the federal court, never ever. Nor his co-counsel, Mr. Tilker. They managed everything under the table through the angels. Folks, you got to understand, this is a federal court. Now, the decision of this slut went to the United States Court of Appeals. Folks, United States Court of Appeal for the Second Circuit is the Court of Appeal for New York and few adjoining states. Folks, again, like in in Atlanta, Georgia, where the 11th Circuit Court of Appeal is located, the Second Circuit Court of Appeal in New York is the same Folly Square. They have to find judges. They have to shop around. You understand? You got to shop around to get the right judges to do what they want him to do or them to do. There are 26 fine judges in the United States Court of Appeal, or maybe more now. Get an order immediately. As soon as I file my notice of appeal before the Second Circuit Court of Appeal, I am getting an order from the Second Circuit which says the regular clerk or the manager who is supposed to assign these cases to judges, she has been transferred, she has been moved. Not transferred, I don't know what happened to her. I spoke to her one time. It's a female, black female. She's no longer in the picture. They bring in a new girl. Her name is Anna Steglich. I have a copy of the docket sheet from the United States Court of Appeal appointing Anna Steglich. That's her name. I never met her. I never spoke to her. Maybe once. So the scheme is, these people, they are the one deciding which panel of judges should get which case. You understand? You understand the name of the game here? What happened in Atlanta? Judge Vance murdered. Somebody murdered him. Judge Vance, the next judge, Allgood, committed suicide. Here in the Second Circuit, the case goes to John Walker. John Walker, as you see, you Google it, he killed a policeman driving through the dirt road. I have driven to Connecticut so many times. I never had an occasion to go through a dirt road. This judge, he drove through a dirt road. He killed a police officer. I'm only citing. He's the one who got my case. One of them. Second one is Rina Ragi, the dancing queen. You can Google and see she's dancing. The dancing queen. The third judge, Judge Rakoff, R-A-K-O-F-F. He's a district judge sitting by designation. Folks, when you file an appeal before the appellate court, you present legal arguments. You are going to argue, and in my case I have argued, that this judge, Seibert, made numerous findings of facts, none of which are going to stand in a proper court of law. You can't take the affidavit of a 2-year-old person, Tilker. You don't have any other material evidence saying that the release is valid. The burden of showing the release is valid is upon the defendant, which they could not do except through the false affidavit of Tilker. This panel, the Second Circuit Court of Appeal, in my case, I wanted to give you the docket number. Those who want to read, of course, if you can get the file, the original docket with the Seibert was 06CV 3199. That's the original docket. United States Court of Appeal, we have another docket. The docket number here is, this is the defendant's brief, 084835 CV, United States Court of Appeal for the Second Circuit. That's the brief. Now, this panel doesn't address any of the issues you raise on appeal. Understand, folks, the name of the game, after selecting the players, you understand? Their mission is simple. You present a legal argument, they don't raise, they don't respond. They simply wing, looking at the party, oh yeah, we don't want to. So this panel, the United States Court of Appeal for the Second Circuit, where the final stop, denies my appeal, although I had raised several legal issues. And the Supreme Court again is a rubber stamp, certiorari denied, because as I told you before, the 9 justices, senior citizens, except Justice Robert, they don't have the time to find out the fraud going on in the courts below. If they are going to sit there, they will be working for the CBI or the FBI or the Central Intelligence. They don't have the time. They only look broader issues. But what is going on under the table in these courts, the justices don't see. Innocent people are executed in America. Crooks, villains who committed murders, bigger crimes, they walk scot-free. They loaf their way to the bank. You understand? This is America, United States of America. I am so mad. Folks, it's not the end of the story. It's only beginning. Folks, as I said before, the Supreme Court denied certiorari, U.S. Supreme Court. Now, these two suckers, Mr. Ralph Curtis Dawson, who is a Columbia School graduate, and Tilker, who studied law from St. John's University, and he got his license to practice in 2006. They think they can go scot-free. No, I am not going to let them go. The rule says if an attorney files false papers, knowing them to be false, they are to be prosecuted to the fullest extent of the law. Is perjury. The punishment for perjury is 7 years prison. Folks, the agency that is supposed to discipline lawyers is called the Bar Council. The New York Bar Council is divided into, I believe, three or four departments. DDC, called District Disciplinary Committee. And the Manhattan comes under DDC, First Judicial Department. Then they have second, the third, and the fourth. 4 departments. Mr. Dawson, who filed the motion for summary judgment and who has an office at 666 Fifth Avenue, Manhattan, I filed a complaint against him and Tilker with the DDC, First Judicial Department. By the time I filed the complaint against Mr. Tilker, he fled to Hawaii. This SOB fled to Hawaii and started working for a law firm, not as a lawyer, but an unlicensed attorney for a firm called Torkils and Katz, Moore and Hetherington. That's the name of the law firm. I filed a complaint with the Hawaii Disciplinary Council. Hawaii says Mr. Tilker is not licensed to practice before this court, Mr. David, so we can't do anything about him. Moreover, the alleged crime of filing a false affidavit took place in New York in 2007. So we have no jurisdiction. I brought this to the attention of the DDC. They kept quiet. Against the allegation about Mr. Dawson, George Dopico is the chief counsel for the DDC, made a motion to the appellate division of the New York Supreme Court. The New York Supreme Court, in the motion he filed, he says, Your Honors, this is Dopico's statement, I am going to show to you that also. He says, because of a conflict of interest, we don't want to investigate Mr. Dawson. This is a notice of motion. This is the blue back. This is the motion. Notice of motion is dated in the matter of an attorney and counselor at law, is signed by Mr. George Dopico, Chief Counsel. Is dated April 27, 2012. He is asking, through his affirmation, that because of the interest, because of the conflict of interest, this case against Mr. Ralph Dawson should be transferred to another department other than the first department. Why? There is a conflict of interest. Understand, folks? Now, before I go into further with this, there were a lot of allegations against the DDC for suppressing crimes committed by lawyers from major law firm. Christine Anderson, if you Google it, you see the article, the video, everything. The testifying before Sampson Committee.
For 6.5 years.
She was an attorney
I alleged
engaged by the DDC itself.
upon learning
And she was a whistleblower.
practice of whitewashing
And they fired her
and routine
from the
dismissing
DDC
complaints
for
leveled
telling the world
certain
there is a
select
concerted
attorneys
cover-up going on with the DDC in New York.
DDC is duty-bound to
Folks,
serve. I
so they
reported
fired
this
her.
wrongdoing
She's a lawyer.
pursuant to my
A
rights
litigation going
under
on.
the First
I didn't follow
Amendment
it up for the
to
last few
United
days.
States Constitution. And
There is another
importantly,
person, Dr. Richard Cordero. He's a PhD lawyer, a lawyer with a PhD degree. He's telling the same story which I am telling you. Folks, there is a cover-up at the DDC. Folks, the first Judicial Department's orders were for the second Judicial Department to investigate against Mr. Dawson in docket number T 923-12. That's the docket of the second department. The investigation never took place against Mr. Dawson by the second department as ordered by the Appellate Division of the Supreme Court. Now, I am getting a letter from a person by the name Robert P. Guido, Guido. That's his signature on this letter. This letter is dated August 27, 2012. That's the original letter. Now, this letter is addressed to me, Grievance Committee, file number T 923-12. The letter reads, a 3-page letter. I am going to read it fast. Dear Mr. David, on behalf of the Clerk's Office of the Appellate Division, 2nd Judicial Department, this will acknowledge the receipt of your motion papers related to the complaints of professional misconduct you made against 2 attorneys. At the outset, I am constrained to advise you that your motion cannot be processed by the court for a formal disposition on the merits. It's not my motion, it is an order made by the 1st Judicial Department, Appellate Division, asking the 2nd Judicial Department to investigate one of the attorneys who allegedly violated the canons of ethics and professional responsibility. This guy, Mr. Guildo, his title is shown as Special Counsel. Okay? He is telling me, as you are aware, your 2 complaints were initially filed with the Departmental Disciplinary Committee of the 1st Judicial Department, DDC. By order dated June 8, 2012, the 1st Judicial Department transferred only one of the complaints to the 2nd Department. The other complaint, retained by the DDC, therefore remains within the exclusive jurisdiction of the 1st Judicial Department, and our court has no power to address your concerns as they relate thereto. That's fine, I have no problem, because they have no business to investigate. A lawyer, another lawyer, Tilker, because it is the 1st Department's duty. The duty of this court is to investigate the other guy, Mr. Dawson. And these guys don't bring it to the attention of the court to do whatever the other court has ordered. This guy, the clerk, is telling, we are not going to investigate. Hear this. Further, to the extent that your motion relates to the complaint transferred here, those papers fail to comport with our court's governing rules and procedures. Folks, I am compelling a court. Another court ordered them to do certain thing, and this guy says, my motion papers do not comply with. They are supposed to act, they are supposed to investigate, which they are trying to avoid, because it's a big fish. You understand? Obama buddy, Rules Committee chairman, they don't want to investigate. Then it says, specifically, the motion is addressed improperly to separate courts, is not made in the context of any matter currently pending before this court, and is not accompanied by a filing fee. Therefore, your papers are being returned herewith. I am sending papers to the court. Folks, you have to hear. And that court was ordered to do certain things by another court. And this court, second department, keeping quiet. And I am compelling the court by a motion to do that. This guy says, no, you haven't paid a filing fee. Folks, in a litigation in America, at least, when a party buys an index, you don't have to buy another index by the other party. Everything is in the same folder. This guy is telling, I haven't paid a filing fee to force these people to conduct an investigation. Here, although your motion cannot be formally processed by our court, nevertheless remains in a position to address in part your concerns. Technically, the second department's rules governing the lawyer disciplinary process do not extend a formal right of appeal to the complainants who are dissatisfied with the handling and or outcome of their grievance complaints. However, traditionally, and as a matter of regular practice and courtesy, the court offers an informal review process for that purpose. Such matters are regularly delegated to my office. Accordingly, the court has asked me to review and respond to substance of your motion papers insofar as they relate to the handling of your complaint by the grievance committee for the 2nd, 11th and 13th judicial districts, thereafter hereinafter committee, and which bears file number T923-12. My review of the file reveals that the committee received the transfer from the DDC on or about June 14, 2012. In accordance with the regular committee procedures, the complaint was examined by a staff attorney to determine what further action should be taken. You understand? The Appellate Division of the Supreme Court transfers some case to the second department. Now the second department, instead of conducting the investigation as ordered by the first department, refer this case to a staff attorney. You understand? One court tells one thing, a 5-judge panel, this guy says, they submitted to a staff attorney. Okay? It is important to understand that the staff is not required to open an investigation in the case of every complaint received. Okay? As a matter of regular practice and procedure, the grievance committee in the 2nd Judicial Department are vested with the discretion to decline to investigate an otherwise valid complaint due to a variety of independent controlling factors. Not says one to investigate, they say no, the staff attorney decided no, we don't want to do it. For example, it has long been the practice since the inception of the Appellate Division supervised committees more than 40 years ago to decline to investigate complaints intertwined with related court action or decision and for which there are clear legal remedies in the first instance, including an appeal. This practice serves to prevent the grievance process from being utilized as a forum to resolve legal disputes. It further prevents parties to a court matter from improperly using the grievance process as an avenue of legal review, and to avoid the possibility of the grievance committee interfering with the matters more properly within the province of the court before which the matter was heard or is pending. For a more complete description of the complaint screening process, please access the detailed information set forth on the court's website by following the following links under Attorney Matters at http://neocourts.gov/courts/AD2. That's what he is telling me to do instead of the second department conducting an investigation against an attorney which was ordered by the first judicial department appellate division. He is telling me they have not done this, they don't want to do it because my avenue is to appeal the appellate court, which I did in the Federal Court of Appeal. Now I am asking the attorney who filed the papers to prosecute him to the fullest extent of the law, which these guys don't want to do. This is a big game plan, folks. It's a joke. The whole judicial system in America stinks in these kangaroo courts. And I wanted to say with reference to all the fine judges in the United States courts, there are fine, honorable judges. Fine, honorable judges. I had occasion to argue a case before Judge Lawrence King. I don't know whether he's alive or dead, and Judge Palermo, the magistrate judge, in whose chambers I deposed the city of Miami. I shook hands with him. They are fine, honorable judges with integrity and reputation. But the defendants know which judge is a crook, which judge can be bought under the table for a price, and many of them do accept bribe. Okay? Now, in this case, this guy, Gildo, Robert B. Guildo, is telling Mr. David, you have to pay a fee to have the docket. Already there is a docket. Then he says, we don't conduct the investigation because the staff attorney decided not to do so against Mr. Dawson, who is a member of the disciplinary committee himself and the chairman of the Democratic Party. So instead of these people conducting the investigation against the guy, a staff attorney decided we don't want to do it. Now, this letter goes on to further, Mr. Gildo goes on to say, your initial letter of complaint dated April 3, 2012 concerns an underlying legal claim that became the subject of extensive litigation which you unsuccessfully pursued through trial and appellate courts on the state and federal level in Florida and New York from or about 1982 through 2009. The attorney who is the subject of grievance, file T-92312, represented a defendant in the federal New York action. Your complaint set forth allegations directly arising from the litigation proceedings, including that he wrongfully failed to disclose to court who decided the matter, that he had held political and court-appointed positions, which you believe serve to prejudicially affect the outcome of the case. Based on these circumstances, it is not unreasonable to conclude that the allegations of your complaint were intertwined with a relevant court matter and therefore are more appropriate for a resolution as part of that process. Accordingly, Staff Counsel to the committee sent you a letter dated July 11, 2012, advising that the committee was declining to investigate your complaints for the following reasons. Now, one more page, folks, it's the last page, and that he is quoting the staff attorney's findings. After careful review, it has been determined that the procedural and the factual issues you raise regarding the summary judgment motion are more appropriate for review by the tribunal which rendered the decision or through any appellate procedure permitted by law in the first matter. The committee has accordingly the committee has authority to review or overturn a decision rendered by the court or other tribunal. Unquote. The response was perfectly reasonable, fully justified by a fair reading of the complaint, and in accord with the standard practice and procedure followed in the second judicial department. Moreover, the fact that the first department under order dated June 8, 2012 states that the complaint was transferred for investigation and disposition does not preclude Staff Counsel from making this determination as you claim in your motion papers, or otherwise bind this court. Upon transfer of the complaint, the second department has authority by law to take whatever action it determines appropriate in relation thereto. Finally, your motion papers submitted to the court also raises the allegation that the attorney suborned a perjurious affidavit filed in the court of the litigation by his associate, where he is subject of the grievance committee retained by the DDC. However, the supporting proof submitted with your grievance complaint reveals that this claim was specifically rejected by the court that rendered and decided the matter. In conclusion, there is no basis to find any impropriety in the manner in which your complaint was handled by the committee. The complaint was properly screened and disposed of in accord with the standard practice and procedure that are well established, grounded in sound policy and consistent with the obligations imposed by law. Under these circumstances, the court remains unable to assist you. This determination does not preclude you from pursuing any legal remedy that may be available. Signed by Robert P. Guido. Okay? Folks, what you have to understand here is I am asking one guilty party be investigated by the disciplinary committee. They say we can't investigate because he is a prominent member of the disciplinary committee himself and the Obama buddy, the chairman. So they are asking the chief counsel to the court to transfer this case to another place to investigate. This guy says, we don't want to investigate because a staff attorney found it's not a case for the investigation. Who is the staff attorney who made the decision? Can he make a determination when there is an order from five-judge panel to investigate this sucker? Mr. Dawson, it's all politics, folks. Any crook can walk away scot-free. These two attorneys are guilty as charged. They are passing the ball from one to the other to the other. That's a gimmick designed to protect them. The court should have made a decision. With regard to this sucker number 2, Tilker, who filed the affidavit, they don't want to investigate him either. Folks, this is a big joke. United States courts and the state courts, especially those cases where the big corporations are involved, rendition of judgment on the merits, on the basis of a law, is impossible. People, believe me or not, judges, if you are listening to me, lawyers, law students, people losing faith every day in our courts. It has become a kangaroo court. It's a coin-operated court system. You put X amount of money in the parking meter, you get 5 minutes, 10 minutes time. You put more money, you get more time. Our judicial system in America has stooped so low, I can't explain to you. I am a law-abiding citizen. I have been and I will continue to be. I am telling the truth. 33 long years I sought justice. There is no way you can get justice. We tried everything. We tried everything. Every avenue open to me, we pursued. There was no way we can get justice. All doors to open to get people justice, they were closed. 33 long years, moving from one kangaroo court to the other, to the other, to the other. And each place, this mafia corporation has such an influence. They have the financial wherewithal. They destroyed me, my family. But by the grace of God, I am still surviving in another part of the world. Folks, anybody wants any information about this, write to me. My email address is trdavid2009@gmail.com. Friends, if you've seen this, either in the Facebook, Twitter, or Google, anywhere, pass on to your friends, and friends in turn pass on to their friends. I want the world, civilized world, to understand how justice is being suppressed. Not against the foreigners. I am a United States citizen. I have got 5 children, all US citizens. I have got 7 grandchildren. We are the one who voted presidents into office. Now I wrote to President Obama, no response. I wrote to Michelle Obama, no response, no acknowledgement. These are 2 law professors who teach law to the young and aspiring Americans about the American system of justice. Folks, I wrote to the Department of Justice, okay, when there was a cover-up going on, and the FBI office in Amityville, in the local office of the FBI, they opened up a file. They acknowledged that they are going to conduct investigation. This is the letter from the Pine Lawn office of the FBI in Melville. This is a letter which says, "Dear Mr. David, this letter will confirm receipt of your recent complaint to our office, dated 5/19/2009. A careful and thorough review of the complaint will be conducted to determine an appropriate course of action. Any decision to initiate a formal investigation will not be made a matter of public record. We would like to thank you for providing us with this information, which will be retained in our file, our office. And signed by Joseph M. Demarest, Jr., Assistant Director in Charge, signed by Richard T. Jacobs, Supervisory Special Agent. The case file number 194 NYC 277070. The reason why I wanted to show to you guys the world is this is what the FBI says to begin with. Folks, when there is a corruption, it's a big fry involved. The cover-up is at the Washington, D.C. Now I am getting a letter from the FBI, Civil Rights Division, U.S. Department of Justice. This is another letter. This letter, I am not going to read everything out to you, is signed by John Gadzowski, Chief Employment Litigation, signed by Cicely Crawford, Paralegal Specialist, Employment Litigation Section. They say in this letter, Mr. David, we are not going to investigate these guys. Under the theory of separation of powers, we can't investigate the other branches of the government. FBI is part of the administration. You are not going to investigate the judiciary, the corrupt and crooked judges. This is the second letter, which also has a file number DJ 170-52-0. Okay? So this is how what the FBI does. They don't want to investigate. The arm of the court, the disciplinary committee, don't want to investigate. The second department say, we don't want to investigate. Mr. David, your avenue is to go to the appellate court, which I did already. This is the way the system of justice in America functions. Folks, I want to make a movie based on this. The kangaroo court proceedings going on in several courts. This is only a tip in the iceberg. I fought so many cases in America, so many of them. Exxon, David versus Exxon Corporation. There, they changed the judges 3 times. If the judge doesn't fit their need, then they change the judge. And if second judge doesn't fit, they get an order from the court saying that this case is reassigned to another judge. That's the Exxon case. I had a case against a CPA firm where I worked. Same issue, same facts, everything. We went for trial before a judge called Miriam Sitterbaum, Southern District of New York. We had the jury selected, seated. I presented my arguments for 3 days. What she does, folks, she does the same thing which the cyber did. After hearing arguments, when the jurors were about to return the verdict, she says, you are dismissed, jurors. We don't need you. She dismissed the jury, then rendered the decision. In that case, one senator's office was involved. His brother is a lawyer running a law firm. So they were able to influence this judge, who first offered me to settle the case. She offered me $10,000. I declined to accept. I spent more money in litigation costs. Then I had another case, City of Miami. Same pattern, same everything, same pattern. First judge was Judge Lawrensky. As soon as they knew they are not going to win, they changed the judge all of a sudden. No reason. These are the things going on in the United States courts. If a particular judge, the party cannot buy them, especially powerful corporations or city or state governments, the next thing is the judge is replaced. The case is reassigned to another judge. Judge Lawrence King was changed from my case, and they got Judge Marcus, Stanley Marcus. Stanley Marcus was afraid. I wrote to senators, congressmen to investigate him. So he says, Mr. David, come for a settlement conference. There was no settlement conference. The defendant filed a motion to dismiss as the Sucker Corporation did it. But I prevailed before another panel of senior judges sitting at the 11th Circuit Court of Appeal. I settled the case. I had so many cases, folks. And the common thread is, in every court in the United States, if you are a powerful corporation and you have insiders, you can beat anybody. The merit of the case has no basis. You pay money under the table, that goes to the wallet of the judges through their sources. And the FBI and other enforcement agencies must investigate this case particularly, how Mr. Dawson and Mr. Tilker, who filed false motion papers and affidavit, walked away scot-free. What about my constitutional right as a citizen of the United States? What about my pension? These suckers and these mercenary judges don't understand. I never swear at a judge. I never called a judge a bitch. But this bitch, who rendered a decision on behalf of the defendant, solely and wholly on the basis of a false attorney affidavit, she must be ashamed. I spit at your face. Pooh! Bloody fucking bitch. This is the America, folks. I am so mad. I am so mad. Words are quite inadequate to give expression to my thoughts, my anger. But I come from the country of Mahatma Gandhi, who taught us ahimsa, non-violence. If I were a local-born American, I would have done something stupid, as many people do in America. But you don't hear them. They put a bullet. They kill him. Okay? The person disappears with no trace. Folks, I am 74. I am not afraid. Let this mafia corporation send me some hired assassins to kill me if they want to. But they are a bunch of crooks. Crooks. They are today in India to destroy this country also. This mafia corporation. And if they have the guts, face me in any debate. I asked Mr. Dawson, face me. He doesn't want to. He knows what he is doing. Filing false papers, holding the political party's umbrella to protect him. And he is a member of the disciplinary committee. Folks, God bless America. I'm a poor American struggling in India. I can't even get my pension, to which I am entitled. I wrote to the Department of Labor, and they say they can't get my even papers. I wrote to this mafia corporation's headquarters. I chased them in Texas. I wrote to them. They can't even find my file, my employment record. Folks, I want to wish all American friends, all citizens, all the best. I am really, really angry. You people, when you vote next time, whatever I said, think about it. I voted for Democrats 40 years. Today, I have no faith in that political party. I wrote to Senator Schumer, Chuck Schumer, my New York senator, who is a Democrat. No response. I wrote to Gilly Brandt, the senator who replaced Hillary Clinton. She said, Mr. David, we are another branch of the government. We can't investigate the judiciary. Whom you go, folks? I wrote to the Inspector General of the Unified Court System. No response. I wrote to the U.S. Attorney for New York. And I got a letter from an Indian gentleman, son of a Sikh. Forgot his name. He says, Mr. David, Mr. Tilker and Mr. Dawson did not commit anything wrong. Because Mr. Dawson went to Columbia along with this attorney. Both are Columbia graduates. So when they do something, you got to have support from all these people. So the bottom line is, during the last 33 long years, a US citizen is suffering. We have an irreparable injury, not only to my reputation, but the relief that I was seeking since 1982. That's the motion, the complaint filed by counsel who was assassinated. That case was never decided, never addressed any of the issues. You're going from one issue, go to another issue, going to another issue, driving the focus or attention from the main issue. Did Mr. Talker commit an offense? Did he commit perjury? Did Mr. Dawson commit the same offenses? Did he violate the rules of the canons of ethics? These are not the issues before the Orlando court. These were not the issues before the Eastern District of New York in Central Islip, New York. But this paid puppet, this paid parrot of the political party, she goes another way. Never, never, ever bothered to present issues. You understand? Never have a trial. This is what is called inviolate constitutional right to a jury trial.